Good morning. This is task 1 of last year's summer internship. My topic is Dowry Death and it is presented by Letwangi from City Academy Law College. Let's begin. The introduction. After independence, the problem of dowry debt became very rampant in Indian society, especially during 1980s. Therefore, the provision of dowry debt was inserted in IPC by Criminal Amendment Act 1986. By Criminal Amendment Act 1986, the two sections were inserted. Section 304B was inserted in IPC in 1866. The Section 113B was inserted in Indian Evidence Act 1872, which is now respectively Section 80 of BNS and Section 118 of BSA. Section 304B of IPC, which is now become Section 80 of BNSA, deals with dowry debt. By analyzing the Section 80 of BNS, we have found that the dowry debt is an offense related to marriage, where due to cruelty of husband or his relative, the woman died unnaturally within 7 years of her marriage. Whereas Section 113B, which was inserted in Indian Evidence Act, became Section 118 of Bharatiya Suraksha Adhiniyam, deals with the presumption of dowry debt. When the question arises whether the person has committed dowry debt or not, and is shown that soon before her death, cruelty was committed on her by husband or his relatives, the court will presume that the dowry debt has been committed. Element of dowry debt. There are majorly 6 elements of dowry debt. First, the death of a woman. Second, the death must be caused by unnatural means like burn, bodily injury or other than any natural circumstances. Third, the death must be caused within 7 years of marriage. And fourth, the soon before her death, she was subjected to the cruelty or harassment. Fifth, such cruelty or harassment must be committed by her husband or her husband's relatives. Sixth, demand. The death must be caused in connection to the dowry demand. Let's understand what is the meaning of soon before death. The soon before death is a very vague term. It is not defined anywhere, whether in BNS or any other act. However, Honorable Supreme Court through various cases have given their views that what would amount to be a soon before death. For example, in the case in Hiralal vs. State of Delhi 2003, in this case, Honorable Supreme Court held that soon before death is a figurative expression. It cannot be confined to a specific period. However, there must be a proximity between the death and the cruelty in relation to the dowry demand. Second, in the case of Raja Lal Singh vs. State of Jharkhand, the court held that the expression soon before death is an elastic term which can be referred to either immediately before her death, few days before her death, or few weeks before her death. In the case of Rajveer Raju vs. State of Haryana, the Honorable Supreme Court issued the direction to the police officer and judicial magistrate which may be followed in the case of dowry. For example, the section 103, the charge of murder must be applied along with the charge of dowry under section 80 of the BNS. The next topic is presumption of dowry death. The section 118 of Bharatiya Suraksha Adhiniyam lays down the presumption of dowry death. When a question arises whether a person has committed dowry death of a woman or not, and it is shown that soon before her death she was subjected to cruelty or harassment or in connection with demand of dowry by her husband or his relative, the court shall presume that the person is caused dowry death. In the case of Sadhbir Singh vs. State of Haryana, in this case, the court held that the prosecution was able to prove the element of dowry death under section 304B of IPC, then the burden of proof will be shifted to the accused. Punishment of dowry death. Section 80, subsection 2 of BNS 2023 lays down the punishment of offense of dowry death. The offender shall be punished with the imprisonment which shall not be less than 7 years and which may extend to the life imprisonment. Thank you for giving me such a wonderful opportunity to present my topic on dowry death.